Good morning. Are you Veronica Randall?
It's Gianna.
And Ms. Randall was previously in court and caused numbers 25 DCCR 0246 and 0247. Entered pleas of guilty to theft of property with previous convictions, a state jail felony. Also entered pleas of true to prior convictions, which enhanced this to I believe, second-degree felony for punishment purposes. The agreement was for a cap of 6 years in prison. I've received and reviewed that pre-sentence report. Have you all both had an opportunity to review that report?
Yeah, Sean.
Yes, sir. Are there any additions or corrections to the report?
All good? What you read? All accurate? There we go. No additions.
Judge, I don't have any additions or corrections. I would just state if it's the appropriate time for the court. When I look at it, I have some empathy for Ms. Randall based on the comments that she made. But how much can we take her out of her word with her criminal history? The court will recall you previously rejected 4 years in this case. I'll defer to whatever you think appropriate. Yeah, Judge.
I also have taken judicial notice of the jail incident reports. You both should have copies of those. Have you both had an opportunity to review those as well?
Yes, sir.
Yes, Sean.
All right, Mr. Vasquez, you may proceed with argument.
Before we go any further, pay close attention to what the judge is reviewing. This isn't a hearing where the court is looking at a single incident in isolation. The judge has already referenced prior convictions, a pre-sentence investigation report, a previously rejected plea offer, and even disciplinary reports from the jail. That's significant because sentencing decisions are rarely based only on the current charge. Judges are tasked with evaluating the defendant's entire history, including whether previous opportunities for rehabilitation have been successful. The defense is asking the court to avoid incarceration, but based on the questions being asked so far, it feels like the judge is trying to determine whether probation and second chances have already been exhausted. And when a court starts looking at decades of history instead of a single mistake, the conversation can change very quickly.
Gianna, I know Ms. Randall's had probation a couple of times in the past, and it didn't work out for her. But I'm arguing for anything that does not involve incarceration. Ask the court to just grant her probation with every condition and
This is one of the most important moments of a hearing because the judge is addressing an issue that appears in courtrooms across the country every day. He acknowledges that there may be mental health concerns and difficult personal circumstances in the defendant's life. In fact, he openly says he has some empathy. But then he makes a distinction that often plays a major role in sentencing decisions. Understanding why someone commits crimes is not the same thing as excusing those crimes. Judges must weigh compassion against accountability, and that balance becomes even harder when a criminal history stretches back decades. The court appears willing to recognize the defendant's struggles, but it also appears unwilling to accept those struggles as the primary explanation for a lifetime of thefts, robberies, and felony convictions.
if the court thinks best would help her to quit offending. And in lieu of that, in the alternative, you're not asked for something less than the 6 years.
This section may ultimately explain the entire sentence. Listen to how carefully the judge is walking through the defendant's criminal record. He's not just mentioning a few prior offenses. He's laying out a timeline that begins in the early 1980s and continues for more than 40 years. Theft after theft, robbery after robbery, felony after felony. Every conviction being mentioned represents a prior encounter with the justice system and, from the court's perspective, another opportunity to change direction. When a judge spends this much time discussing a defendant's history, it's usually because that history is heavily influencing the outcome. The focus is no longer on what happened in a single case. Instead, the court is evaluating a long-standing pattern of behavior. And the longer that pattern continues, the more difficult it becomes to convince a judge that another chance will produce a different result.
Anything else, Ms. Mulvaney?
Judge, I don't have any additional comments. I would just state that our agreement initially was to dismiss the
The first prison sentence has now been imposed, but the hearing is far from over. In fact, what we're watching is a reminder of how complex criminal sentencing can be. Multiple cases are being resolved during the same proceeding, and each one must be addressed separately on the record. That's why the judge sounds so methodical as he moves from case to case. Every conviction, every enhancement, and every sentence has legal significance. What stands out here is the contrast between the calm atmosphere of the courtroom and the enormous consequences being announced. There are no dramatic interruptions, no emotional outbursts, and no last-minute surprises. Instead, there's a steady process that will ultimately determine years, if not decades, of someone's future. And based on the direction this hearing is taking, it seems clear that the most significant penalties may still be ahead.
new case because she already has the sequence felony priors that would enhance anything further. But if the court disagrees with that, we can visit about it after the sentence.
So, Ms. Randall, I made some notations on this pre-sentence report, some issues and maybe some mental health issues that have contributed some issues in the past. However, there's nothing in here that makes me believe that any condition you may have is what requires or makes you go out and do what you've done. Literally since 1981. Your first theft that I have here was from an arrest from 1981. Then I have one after another misdemeanor thefts through 2018. Then we've got, starting in 1986, a robbery and a theft. And then we've got 13 felonies since then. These are your 14th, 15th, and I guess 16th felonies. At some point, you got to figure it out. There's opportunities when you are not incarcerated and not on probation to get the help that you need if that's what you think is the problem. I think the problem is you just like to go steal or rob, because I mean, we've got robbery, aggravated robbery, another robbery. Anyway, so at this time, in cause number 25 DCCR 0246, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find the other previous convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0247, I'm also going to find sufficient evidence to find you guilty, find those prior convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. In cause number 26 DCCR 0312, find sufficient evidence to find you guilty and find all those counts true, and in that case sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26 DCCR 0313, find sufficient evidence to find you guilty, find those prior counts true, and at this time find you guilty of unlawful possession of a firearm by a felon, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26 DCCR 0314, find sufficient evidence to find you guilty, and at this time find you guilty of abandoning or endangering a child, find those prior convictions true, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26 DCCR 0315, find sufficient evidence to find you guilty and find all the prior convictions that you pled true to true, and at this time find you guilty of theft of a firearm, find those convictions true, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 26, DCCR 0316, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated kidnapping, find those prior convictions true, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these cases will run concurrently, which means together at the same time. It shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Vasquez.